members, we do have a quorum. Thank you for your attention. First on our agenda is House File 1503. We'll be using this as a vehicle as we get to the end of session. So members, I believe all of our language was posted on our site. So if you could pull that up there, and Ms. Strand emailed it to you as well. So with that, members, I'd like to move House File 1503 be recommended to pass and placed on general orders. Remember to unmute, turn on your video, and use signal and audio.
In terms of the
Thank you. I'm watching. Okay, members. And we're waiting. We've got a couple more connecting here. Okay, Senator Nelson, could you unmute? Thank you. All those in favor say aye. Aye.
Aye.
Aye.
Aye. Thank you. Opposed? Thank you, members, for assisting. House File 1503 is on its way to general orders. Next, we'll have Senate File 4603 dealing with medical malpractice. We are the committee of first jurisdiction, and so we do have broad authority to go over the content of this bill, but I ask you to pay special attention to the areas that we regulate licensing to make sure that the folks that we take care of are included in this language. So I'd like to place Senate File 4603 before the committee. Members, COVID has brought us to a lot of extraordinary places. We use the word extraordinary all the time. Extraordinary means out of the ordinary, not things that we do every day. And for those of us who run committees in an extraordinary way via Zoom, there's very low risk. But there are people who care for COVID patients who work in facilities where there is COVID. The medical profession is taking extraordinary risks that I don't know the public fully appreciates or understands. And I am deeply concerned that there will come a time of second guessing for people who don't get to have second guesses. And that's why I brought this bill before you today. Senator Klein agreed to co-author, as did Senator Jensen. Senator Klein, would you help the committee understand some of the kinds of decisions that are going to have to be made and are being made in the medical field? And so, Senator Klein, if you would unmute and begin.
Thank you, Madam Chair. Yes, thank you, Madam Chair, and thank you for the bill. I did gladly author it with you. I do think we need to, keep working on it together, as you have so gratefully done thus far. And members, I think you know from looking at the bill, but broadly what it does is offer temporary immunity from liability for people who are, for medical practitioners of all levels, physicians, nurses, nurse practitioners, et cetera, who find themselves in extraordinary circumstances, either due to lack of sufficient equipment or strained resources, or practicing outside their usual area of specialty out of necessity or demand. Just to sort of bring my own personal perspective, obviously, on this, I haven't worked the last couple of weeks at my hospital because I am finishing session. That's usually the way I do it, but I stay in close contact with the physicians who do. And they're telling me that, their ICUs are now full and they've opened up additional ICUs. Their shifts are extremely busy. It will not be long before they start asking people from other specialties to join them and pitch in. And we're going to work as hard as we can to get pediatricians and family practice docs and regular hospitalists like me trained in ventilator management and ICU infusion management and so forth. What we don't want is for there to be any hesitancy on the part of those practitioners to chip in and do the good and necessary work that they have to do because they're afraid of a lawsuit or liability. Medical culture is naturally risk averse. I can tell you that is the real concern by practitioners, and recruitment efforts would be hampered if that was a concern. This bill attempts to address that by encouraging practitioners to practice to the very best of their ability in extraordinary circumstances. Where there's precedent for this in Minnesota legislators, we have a Good Samaritan law, and almost for the same reason. We want doctors, if they drive by, say, an accident or something like that, to pull over. And in the past, they might say, well, what do I know? I'm a dermatologist. I don't want to go out there and mess things up and cause, get sued. And the feeling of the legislature was, go out there, do your very best. We will give you immunity from liability, but we want to encourage the idea of chipping in. And I can tell you that law has a tremendous impact on the culture of medicine. People are aware of it, everyone's aware of it, and it has sort of driven a spirit of participation in community service by physicians. I think this bill would have the same salubrious effect. It would encourage practitioners to just chip in and do the very best they can in what we anticipate are going to be extraordinary circumstances, and it would improve care. I recognize that we have a letter on the table, Madam Chair, from some of the senior care groups and elder care groups who are concerned that essential protections will be lost for people who reside in communal settings or senior care settings. And I'm willing to continue to work on that. That's not obviously the intent, your intent or mine. So if we can somehow fix that and yet still solve the problem that I've spoken to, I'd be very grateful.
So thank you, Senator Klein. The people on this committee and the people who follow it know better than anyone else what is being done in healthcare to fight COVID. So long-term care facilities are having to figure out how to quarantine residents who, because of dementia or conditions, can't fully participate in the choices of quarantine. How do you safely quarantine someone in their residence? How do you make that choice? And are you making the right choice at the right time when MDH guidance and CDC guidance change literally week by week? Hospitals are using overflow space. Is the level of care up to their ordinary, very good standard? What if you get 10 vials of a new FDA-approved drug and you have 14 COVID patients? Who chooses who gets those 10 vials? And what if doctors disagree on how to make that choice? Do they just wait until they only have 10 patients or until they have 14 vials? Or do we want them to make a decision and do what they can do with what they have? And it will be easy for us to second guess. But we will have months and years to second guess decisions that they are making at the moment. What about the EMT who's never used portable ECMO or used it once and is now in an ambulance with a portable ECMO moving a patient who needs to be moved from Brainerd down to Fairview so that they can get the ongoing care they need? What happens to that EMT team if they're doing their best, if they're acting in good faith, and somebody decides to second guess them? Prone venting. When did we learn that prone venting might work for COVID patients? Was it after a peer-reviewed journal and presentations at conferences and well-monitored, stable in-hospital procedures, well-documented? Or was it because somebody figured it out and shared the information? And what if one hospital uses it and another one doesn't? Or what if one doctor's judgment is this patient doesn't need it and that patient does? And then they get to be second guessed without the benefit of a peer-reviewed journal, with all the hindsight in the world, when they had to make decisions, doing the very best they could and acting in good faith. What do we do if there's a shortage of medications for people who are on vents? This is very real. if you've been talking to your hospitals, they started planning for reduced usages in PPE and meds that go with vents. They started it well before our first person was ever on a vent because of COVID. So we have very real challenges. Our medical community has very real challenges, and we need to have a robust conversation about how we help them make confident, correct, non-hesitating decisions in the moments when we would ask them to do that. So when you have somebody prone on a vent, you need 2 nurses. So do you have 2 ICU nurses when you're already short-staffed, or do you have 1 ICU nurse and bring a nurse up from med-surg who probably hasn't worked on a vent in a very long time? Do you take that risk? These are the decisions that are going to be second-guessed for the years to come. So let me begin walking through the bill. Obviously, subdivision 1, definitions. We've had Ms. Kavanaugh review our definitions. Healthcare provider organizations, healthcare services, diagnosis, prevention, treatment of COVID, assessment or care of an individual with a confirmed or suspected case of COVID, and members, paragraph 3, lines 18 through 20. There's a lot of controversy here. I want you to pay attention to that language. This is not directly related to COVID. This is more directly related to the executive order that delayed elective procedures. So for example, the doctor who discovers macular degeneration schedules an injection, the executive order goes in place, you can't do elective procedures, PPEs all required to be sent to the state, you can only keep limited PPE, and in the doctor's judgment, they think this patient will be okay for the weeks to come. But then it turns out the patient has a spot where their vision starts to be occluded. So we are also talking about the impact of delaying medical care. Then we move on to home care service provider, long-term care facility, peacetime health emergency, responder. I believe there are amendments to this section in particular. Healthcare provider organizations, including physicians, physicians assistants, nurses. Then moving on to paragraph 2, long-term care facilities, physician assistants, pharmacists, registered and other nurses, and looking at direct care staff of a long-term care facility. So this isn't somebody who doesn't have patient contact. We know that that has been a challenge. Home care service providers, registered and other nurses, optometrists, pharmacists. So I'm moving through the list here. Emergency medical technicians in paragraph 5 and continuing. Then we get to the heart of the matter, and this is, for those not on judiciary committees, this is all new, foreign to me. The immunity provisions. So it's a responder who is acting in good faith. And there is a lot of back and forth over what the term acting in good faith could be. Is it not acting in bad faith or not acting? There are other standards that could be used there. Is immune from criminal, civil, or administrative liability. Criminal, highly controversial. We'll let you know that. Civil, obviously torts. Administrative liability, that's sanctions against a license for harm or damages from the responders, act or omission. So something they did or something they did not do. So that is the choice to give someone this kind of care or the choice to not give someone this kind of care. As related to the provision of healthcare services, including providing, allocating, withdrawing, or delaying arising out of the state's response to COVID-19 during the peacetime public health emergency. So if there's no peacetime public health emergency, there is no even beginning of a cause of action. So when the peacetime emergency is lifted, You can't use COVID as an excuse. COVID's not actually an excuse during the peacetime emergency, but we're giving special attention to the unique circumstances that would bring about a peacetime emergency. The exceptions, this does not apply if the harm or damages were caused by an act or omission constituting intentional or reckless misconduct or gross negligence. So you can't just get away with things under this. You have to be grossly negligent or reckless. For purposes of this subdivision, omission resulting from resource or staffing shortage does not constitute intentional or reckless misconduct or gross negligence. The effective date is actually retroactive to the declaration of the peacetime emergency because people had to start making decisions in that environment at that time. I do want to go to, we do have some questions from members. I'm going to go to Jensen, Kiffmeyer. Actually, Senator Klein, could we do your amendment and talk about that, and then we'll go to members and then testifiers.
Madam Chair, I move the A4 amendment.
And members, I believe the A4 was sent to your inbox as well. Senator Klein, could you explain the A4, please?
So it clarifies some of the definitions under the first section. Physicians is specified to include podiatrists and advanced practice resident nurses are clarified to be consistent with other statutes. So it addresses the definitions, Madam Chair.
Okay. And questions from members to the A4? Okay, seeing none, I'm going to ask you to unmute, turn on your video. Right. I'm seeing a couple of folks. So Senator Franzen and Senator Eaton. This will be my last call. Okay. To the A4 amendment, all those in favor say aye. Aye.
Aye. Aye.
Aye.
All those opposed say no. Okay, and the A4 is adopted. And thank you. I'm going to go to members' questions. So Senator Benson, then Kiffmeyer, Eaton. This will be my last call. Okay. To the A4 amendment, all those in favor. Okay. I'm sorry. It sounds like we're getting some feedback. There must be a little delay. Say no. Thank you. So first on the list is Jensen, Senator Jensen.
Thank you, Madam Chair, and thank you, Senator Klein. Madam Chair, I want to speak to the bill, not the amendment. The amendment's passed, so am I to the bill?
To the bill as amended, yes.
Yes, okay, thank you. I think you've done a nice job of putting something very important together. Again, I've mentioned this in the past, but Senator Klein and I do see different patient populations, and I'm afraid that the patients that I see may be substantially more mundane, if you will, because I'm not in the hospital setting or the ICU setting like Senator Klein is. But to me, one of the things I'm seeing is a lot of physicians being uninterested in getting involved because there's so much unknown. They don't know where the testing can get done. They don't know how long the lag time will be. They don't know what the frequency of false positives and false negatives are. When I've been on call at night, I've gotten many phone calls from people saying, gee, I've got a low-grade fever and I've got a cough, and what should I do? And, you know, I try to exercise my best judgment, but if every person I talk to that has a cough and a low-grade fever I send to the emergency room, I don't think I'm doing the healthcare system any favors. Again, I think physicians are trying their best. You have a section in your bill where you identify recklessness or intentionality, and I think that does cover it. What we want to have happen in this pandemic situation is we want people to feel like they're being cared for, and that doctors won't, if you will, feel intimidated by the lack of knowledge. I think this is important. I really do. I know that in nursing home situations, people are frightened to death of making the wrong decision. And nursing homes, they're not easy. It's oftentimes a frail, high index of severity group of people that you're taking care of. And I really think that some measure of protection makes a lot of sense. So I do think the bill is good. I appreciate Senator Klein's concerns because he's working hard to make sure that we're not having unintended consequences by doing this. But I really think that we should do something like this. This is uncharted territory, and I do feel like physicians sort of want to turn away if they're not going to be protected. Thank you.
Thank you. Next on my list, Senator Kiffmeyer, then Senator Klein. Senator Kiffmeyer.
Thank you, Madam Chair. I agree too. I think this is a bill, and Senator Jensen, Senator Klein said some really good things. I think most of the examples, though, that we hear are a lot of hospital-based, and I appreciate hearing Senator Klein talking about nursing homes and long-term care. They're particularly vulnerable, and especially without, I think there's a lot of nursing homes and these kinds of places that count on family members visiting, being with them, and noticing things. And it's more of a home-like thing than a crisis thing, even though they may be very, very ill. And so I'm going to wait and see what Senator Klein is able to maybe do, and I want to hear the testifiers. I just wanted to speak to the fact that I think these kinds of long-term care, I think there needs to be some immunity, but I'm just concerned that it may be going just a little bit too far, especially where intentional or reckless or gross negligence and some of these things, and like even in regards to resource shortage, did they make the effort? Did they make the phone calls? Did they do due diligence? And even with all of that, then there was a shortage. That's very different than there's a shortage without an effort to meet the need. And I think that consideration is the kind of thing that I think we may need to add some other clarifying words. And since Senator Klein is already working on it, I will wait for that and see what happens there. It won't stop me from voting for the bill, just because I would if it weren't for the fact that there's some effort going to be going on to moderate that particular population.
Thank you, Senator Kiffmeyer. And you're right, people have to be acting in good faith. They have to be making their best effort. We expect that they will be doing that. Otherwise, you're right, they shouldn't be given immunity. Senator Klein.
No, Madam Chair, my hand is back down. I was going to offer the amendment, which we.
Okay, thank you, Senator Klein. And then I have Senator Marty.
Thank you, Madam Chair. I don't want to disagree with any of the folks who are saying how we do have a gap here we have to fill, where people are called on to do things that are out of their scope of traditional work, and where we're asking people to step up to the plate and do it. And I understand the need for some liability. I do have some real concerns that this is going too far. I mean, we've tried to balance the laws we have already in a way that it does for things like that. And I'm concerned that this is doing far more than we should. When I look at the language, the bill, and it's talking about responder acting in good faith, when they're talking responders here, looking at the definition, it does strike me that almost a whole lot of things are only marginally related to the COVID thing, people who are getting care otherwise, from an optometrist, from a therapist, from all sorts of other medical professionals. The law is designed to go after bad actors, and we can all agree or disagree with whether it does a good job of that. But I'm very concerned that this is going too far. And again, exempting them from criminal as well as civil is a big question in my mind. I think our standards should make it tough so you can't do frivolous lawsuits against people. But I also think the point of our law is to make sure people are doing the right thing and that the patients that the public has some response. So I'm in favor of working on legislation like this. I'm not sure that this is close to where it ought to be, though.
And thank you, Senator Marty. And we're going to, and Senator Franzen, I apologize. I'm going to try to go to testimony. I think it would be helpful for us at this point now that we've gotten a good bed laid. So I have Joel Carlson and Chris Messerly, and then we'll move to Carrie Thurlow, Ben Peltier. So Mr. Carlson, if you could unmute, and we're going to try to keep it to 3 to 5 minutes. So please introduce yourself for the record and proceed, and everybody take notes because there's a lot to learn, and I am really impressed with the level of care that members have taken to balance patients and the provider. And so take good notes, help me get this bill right. Welcome, Mr. Carlson.
Thank you, Madam Chair and members. My name is Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I'm here on behalf of the Minnesota Association for Justice. Our association is dedicated to protecting the legal and constitutional rights of Minnesotans, including their right to a trial by jury. And like all of you on this Zoom meeting, we are very thankful for everyone working in the healthcare field right now. Their efforts are heroic, and we're grateful for everything that they are doing. And we also feel the fear and anxiety, like everyone is, for their families and their loved ones and their businesses and their communities. This pandemic has spared no one from damage. And whether we're staying at home or staying away from the Capitol, which is really hard for me after having been there for 40 years, we're all trying to do our part, to keep everyone safe. Over the years, we've worked on dozens of legislative immunity requests, and we take these very thoughtfully and seriously because when you grant a legislative immunity, you're giving away someone's constitutional right. And so we take these very seriously, and we ask the question, what is the problem? How will this solve the problem? And what happens if the legislature grants a immunity that eliminates accountability for an injury that otherwise we've recognized by law? Because that's what this legislation does. And over the years, we've supported many legislative immunities, whether it's Dr. Klein mentioning Good Samaritan or volunteer trainers. We've supported many immunities over the past, but we do it when it promotes a public good. And not that this is not a public good, but we have never supported, and this legislature has never supported, a guarantee of legislative immunity for negligent conduct for people who are getting paid to do their jobs. We've just never done that. And quite frankly, such protections we think can have unintended consequences of lowering the incentive for people to act reasonably and with reasonable care. So we believe the questions that you're asking, what are the standards for doctors practicing outside the scope of what they normally do? What is the standard of care and legal review for COVID-19 treatments? And what do you do when you have a situation where care is delayed by an executive order? We think these are all legitimate questions to be asked. Mr. Messerly is going to follow me, and he's going to talk a little bit about why we think the current law protects everyone in these situations, but they're not illegitimate questions to be asked. We'd maybe come to a different answer to it, but they're not questions that shouldn't be asked. But when we're explaining the legal part of it, we want you to know that we're not here to find fault or blame with healthcare providers. Our goal is to protect your legal rights. That's what our mission of our organization is. And when you're in a care facility, you really only have 3 ways to protect yourself. You can have frequent visits from your family. You can have government regulation and inspection. Or if everything else fails, you can seek accountability in our courts, and that's our constitutional right. This legislation, the way it's drafted, eliminates the last bit of accountability that we have, because we've all seen the pictures. You're standing outside the nursing home looking in. You can't go and see your family members right now. Government regulators are stretched to the max, and they're not doing inspections. So this legislation, in our mind, eliminates the only accountability that we have, which is our right to seek redress in the courts when we've been injured. We're happy to answer questions that you might have, including the legal questions that you might want to punt over to the Judiciary Committee. This is very important. You're talking about foundational rights for every Minnesotan, and I hope this committee seriously considers that. We don't think this bill is a solution to the problem that you're trying to address, and we think it has substantial negative consequences for people in care facilities that are being treated for COVID-19. We appreciate your time. We're happy to answer questions, and I'll turn it over to Mr. Messerly.
Thank you. Mr. Messerly?
Yes, I'm here. Thank you for allowing me the opportunity to speak with you today. I'm speaking from Vadnais Heights, about 10 miles north of the Capitol. I am a past president of the Minnesota Association for Justice. I'm a member of the American Board of Trial Advocates and a member of the American College of Trial Lawyers, the latter two being groups of defense lawyers and plaintiffs lawyers nationwide. And for nearly 35 years now, I have represented individuals, mostly in the area of medical malpractice. And I presently represent a number of doctors, nurses, and other healthcare providers. One point I would like to make, and I think it's probably my most important point, is that our law for ages has made accommodations for dealing with extraordinary circumstances. The black letter law that judges and juries and everyone else is required to abide by judges conduct of healthcare providers under the circumstances. So in every single case, people are judged under the circumstances. These are truly extraordinary circumstances, and the wonderful job that our healthcare providers are doing is extraordinary. It's uncharted territory. There's lots of unknowns, but one thing that is not unknown, that is crystal clear, is that our law requires a look at the extraordinary circumstances to judge conduct. So I can give you a couple of examples. We want to encourage healthcare providers to pitch in. There may be a nurse who usually is at a pediatric clinic who's working in the emergency room, who may lack knowledge, who may make mistakes. Will the law hold her accountable? No, because under the extraordinary circumstances that the law requires, we want to encourage that. A good friend of mine is a urologist, and he and I were talking a couple days ago about his feelings and his patients' feelings that he could not perform surgeries on people with on men with prostate cancer. Having been one of those people, I know how it feels. But would anyone have a claim for not being able to perform that elective surgery and others, even though it's very serious? Absolutely not, because the law would say under the extraordinary circumstances, there would be no claim. If there were only 10 vials of medication for 14 patients and doctors disagreed but end up making a decision, these 10 get it and these 14 don't. Maybe because four don't. Maybe because those 4 are, like me in their 60s and the other people are in their 20s. Would they be held accountable? No. There would be no second guessing of that because the law provides and has provided for ages that it must look at the circumstances. So there can be no second guessing. One concern I think and Mr. Carlson touched on is this statute, based on what I can tell, is unprecedented in our state's history. There has never been blanket immunity for people who are paid for what they do and are insured for it typically. There's great harm to Minnesotans. It deprives Minnesotans of important civil rights. Every single Minnesotan has a constitutional right to a remedy and a jury. It takes that away. And unfortunately, you would harm those most severely harmed in Minnesota, namely minorities who are disproportionately affected, and it would punish senior citizens who are often dying because of unsafe conditions in facilities that are cited again and again for violating things.
Thank you, Mr. Messerly. So we had about 3 minutes per testifier. So if I could ask Carrie Thurlow, and I appreciate Zoom calls because I don't have to ask people to leave the table, but they're still available for member questions. So Carrie Thurlow and then Ben Peltier. And I understand that Carrie Winning is available for questions on behalf of the MMA, but she is not testifying. So Ms. Thurlow.
Thank you, Madam Chair. And members of the committee, thank you for the opportunity to testify this afternoon in support of Senate File 4603. Just for the record, my name is Carrie Thurlow. I'm the Senior Vice President of Advocacy for Leading Age Minnesota, but I'm also here on behalf of the Long-Term Care Imperative. I just want to take a few minutes to explain why this bill is so important for senior care providers and why extending immunity protections just during this pandemic will be important for two important reasons. One, to ensure appropriate public health responses during the pandemic and to not discourage help. And number two, because of the constantly shifting standards of care, especially as it relates to senior care. The coronavirus pandemic has highlighted our country's critical shortage of tests, critical care equipment, protective gear, and professional caregivers. Just as surely as hospitals and their teams of doctors, nurses, and caregivers are on the front line for stopping this virus, so too are nursing facilities and housing providers. We have already seen the impact of not having liability protections during this pandemic. While there have been thousands of furloughed healthcare professionals that could come into senior care settings during our workforce shortages, they continue to express reservations to fill open positions during this pandemic. The lack of staffing has led at least one senior care provider to evacuate its entire facility during an outbreak, and ultimately that facility is now permanently closed. The state's COVID-19 preparations rely on senior care settings to voluntarily become COVID-19 support sites. This is where facilities have established separate physical areas, such as a floor or a wing, to serve COVID-19 positive patients outside of the hospital. These are critical to allow hospitals to discharge less severe cases and to ensure adequate hospital capacity during a surge. If the state does not extend liability protections, this may have a chilling effect and lead to an insufficient number of COVID-19 support sites, potentially creating hospital discharge difficulties. But in addition to hampering our ability to respond to the COVID-19 crisis, it is really important to understand that the standard of care during this pandemic has constantly shifted as we get more and more information. The guidance that our members are receiving at the state and federal level literally changes weekly. And what was common practice in March may no longer be the case in May. And it is unclear what standard of practice would be applied in a lawsuit. So let me just quickly go through a few examples. We've heard a lot of discussion about PPE. And I want to be clear that senior care providers are still extremely limited in their access of PPE, despite constant good faith efforts to try to get it. They are reporting that there are not enough masks or not enough gowns, and that it takes a lead time of at least 8 weeks to get some of these materials. As a result, they are forced into reusing and conserving PPE in ways that might comply with conservation practices, but do not comply with what would be used in standard practices and do not necessarily comply with manufacturer guidance. In these situations, it is not clear what the standard of practice would be applied in a lawsuit, and it is clear that costly litigation would be required to resolve that. Senior care providers are caring for vulnerable adults with limited availability of tests and testing capacity. The guidance for testing is constantly changing, both at the state and the federal level. Different states have different approaches to testing. So our providers on border communities may have different standards to meet, depending on whether their setting is on one side of the river or the other. Many individuals who seek testing, even some employees that might be symptomatic or have been exposed, are not always receiving tests. While I understand that we are making progress in testing availability, we have not achieved widespread testing. And the limited availability of testing has introduced additional risk in congregate care settings, as providers may not be able to identify asymptomatic carriers. This creates potential liability for the mere presence of COVID-19 in these settings, but it is absolutely out of the control of the provider. Return to work guidance has continued to shift. In March, there was zero tolerance for anyone who was symptomatic or who was asymptomatic but tested positive. In March, those providers or those employees were required to stay home at least 14 days. The guidance has changed twice since then. And now current guidance allows staff with a positive test but no symptoms to return within 10 days. For asymptomatic individuals that have no symptoms within 7 days can come back early. So again, it's not clear what the standard would be. Screening criteria has changed and continue to evolve. Not only have the symptoms for screening have changed, but the frequency have changed. We started only screening residents once per day. We are now up to 3 times a day in nursing homes and twice a day in assisted living. Other guidance related to COVID-19, both from the state and the federal officials, have continued to change. Examples include guidance related to congregate dining and transportation and isolation of residents. At times, guidance has conflicted between state and federal sources, and senior care providers and their staff are doing their best to comply, but the constantly evolving environment makes it difficult to determine liability and the standard of care. Subjecting our members to lawsuits, even when they could potentially prevail, is expensive and could force providers out of business when we can least afford it, given the looming demographics of this aging population.
Thank you, Ms. Thurlow. And again, members will do questions after everybody's done. Mr. Peltier, MHA.
Thank you, Senator Benson. I am Ben Peltier, the General Counsel for the Minnesota Hospital Association, and together with Carrie, I'm here representing a really broad cross-section of healthcare providers who are dealing with these extraordinary challenges as they try and respond to this COVID pandemic. All of the prior speakers have done an excellent job of outlining the range of challenges that are facing Minnesota's healthcare community. And in dealing with these challenges, the really important thing to keep in mind is that healthcare providers are being put in that very difficult position of making decisions and choosing from suboptimal options. This is not the ideal world. This is not the healthcare world of 1 year ago. And they're being put into making these difficult decisions all over the place. It's in emergency departments, it's in the back of ambulances, it's in medical offices, it's by home care workers in private homes. In the not too distant future, it may be in the state's alternative care sites. And when we're placed in these very difficult decisions in the first place, we are compounding that challenge with the threat of a lawsuit. And that's why we're here today supporting this legislation. I want to reiterate that the bill is carefully tailored to provide protections to providers, but it's not so broad that it'll be protecting bad actors. Liability protections contained in Subdivision 2 only apply to healthcare providers whose work and their options are limited by the COVID-19 pandemic. And Subdivision 3 contains important limitations to make sure that only those actors who are acting in good faith to respond to this pandemic are immune from liability. The first two testifiers mentioned how this proposal is unprecedented in history. And that may be true, I don't know, but I know for a fact that this pandemic is certainly unprecedented in history. And the other really key point to keep in mind is that the current law protections that are available for medical malpractice that were referenced earlier only protect you once you're actually in the lawsuit, once you're there in court. The nurse that was talked about earlier, or the urologist that was unable to perform those procedures. The protections that current law provide only protect them once they've already been subject to a lawsuit, once they've already retained an attorney, once they've already gone through a full process. And then the last point I'd like to make is sort of reiterating something that Carrie mentioned. Current law, the current jury instructions provide the guidance based on the standard of care. And it is just impossible in this current environment to understand what the standard of care is going to be several months, several years from now when a lawsuit occurs. Just to conclude, every sector of the healthcare community is being forced to make decisions like this, and the available options will be limited by factors. The available options to those providers will be limited by factors outside of their control. Providers are going to be forced to choose between bad options, and this legislature really could take steps to incrementally reduce their exposure to lawsuit. I really appreciate your consideration of this issue, and I especially appreciate the rapid way that you've considered it. Thank you.
Thank you. Questions from members? I'm not seeing hands raised, but I have started a list. Senator Franzen and then Senator Abler. Senator Franzen.
Thank you, Madam Chair. I appreciate the intent of the bill. This is probably one of the hardest bills I probably have had to vote on, and I don't think I'm prepared to vote on it just yet. It's complicated, obviously, and I'm an attorney. I don't know if there's anyone else who's an attorney in our committee, but you talk about standard of care under reasonable circumstances, and a reasonable person in law school in hypotheticals or in cases that you read in your law books. But this is real for Minnesotans, and this is a really tough one to figure out how to protect our first responders at the same time, how to protect our patients and our Minnesotans. So I think I need more time to digest this and understand all the implications. And I really appreciate Joel and Mr. Carlson, and Ms. Thurlow and Minnesota Hospital Association. I understand the pressures that all of us are facing when it comes to protecting, taking care of Minnesotans, but also protecting people from liability in case something does go wrong and it's without intent or neglect. But I just needed to put that out there because I don't think I am in the position to make an affirmative vote on this at this point until I get more comfortable and until this bill gets more robust discussion. And I'm sure that's going to happen in judiciary, and I'll be looking forward to that. But from a healthcare perspective, which is our jurisdiction, I can see why it's needed, but I also put myself in the shoes of those who might be affected as well. So I don't think there's a right answer, and I don't. We can characterize this in ways that I wish we didn't have to even contemplate. But I appreciate the intent of the bill. I will not be supportive right now, but I will be paying attention. We have 3 days to make this right, and I wish we can say, let's look back on how it all worked out and do reforms for liability, but I don't think that's a solution either. So we really have to think really deep and hard on this one. So I can take more questions offline with all the presenters because I do want to make this right. So thank you. I appreciate where it's coming from.
And thank you. And Senator Franzen, given I think you're the only lawyer on the committee. I'm looking around and I think you're the only lawyer. No, Senator Matthews, because you and I talked about this and the understanding of what intentional and reckless misconduct or gross negligence means. That's not the way our committee speaks. And so I am going to be asking for a hearing in judiciary. The immunity from criminal, civil, or administrative liability. I think we need to brush up against those things really hard. I didn't bring this bill here as carved in stone. I brought it here so that we could shape it to do the two things. And why are we in this committee? Because we care for the providers and the patients. This is what we do every time we meet. And that's why it's here first, so that we can dive deeply into this with the care that we do every single day. And so I understand there are people who will be uncomfortable with the vote, but this is to be shaped and formed over the days to come. And so I'm going to keep moving through the list. Senator Abler, Senator Jensen. I saw Senator Matthews on mic. If you want to be on the list, raise your hand and we'll get you added. Senator Abler.
Thanks. Can you hear me? I've been having a confusing time with the mute and unmute buttons. It shouldn't be that hard, but anyway, you might hear a sound in the background. If it gets too loud, if it gets too loud, I'll turn it off and come back when they quit sawing. I appreciate the need for this liability thing. Actually, given in my career, this has been a topic from the very beginning of my training, and I'm familiar with all those words. And frankly, the very idea that those words could apply to me give me a standard of care that I choose to deliver on all occasions. And you actually met my mom here a few minutes ago. So my standard of care is that too loud? Okay, is that
Please proceed, Senator
We're
Abler.
going to stop. All right, sorry. But so how I would hope somebody would treat my mom is my idea of a standard of care. And I understand from listening to Mr. Peltier and Ms. Thurlow and the others, the challenges that we have and the need for something like this, perhaps. But I am afraid that we are going to give up something. Is that terrible? Okay. It's almost done.
Keep going, Senator Abler.
Okay. Anyway, but I'm really afraid that we're going to give up something. If you look at the words, it's like cutting everything. Let me just, that's got to be just, oh, he's done. Okay. So if you look at what we're allowing in this bill, and I'm concerned that I didn't hear any interest already in changing some of these words around. But the word immune is a big word. Means nothing can happen to you at all. That's what immune is. Any harm, or any damages. That's a lot of damages. And any act or omission, omissions are huge. Something you, oh, I should have done something and I didn't. And the idea about arising out of the state's response to COVID, I don't know if you've noticed, Madam Chair, I've been on the floor for 14 speeches talking about ill effects of the state's response to COVID that have nothing to do with healthcare, but are broad across the whole state. These are not very constraining elements. And in fact, to step out of the constraint and not be immune, you have to be intentional, reckless, or grossly negligent. Those are like really bad things. And so, and I won't go on long, but I think this is really important. And if Senator Franzen's worried, I'm willing to say I'm extremely worried about this. And so people have an expectation of standard for care. They go into a clinician and they expect that they are the right clinicians and do the right thing for them at the right time. And it's hopefully going to have the same outcome that usually it has. At the very least, your bill has to include disclosures. By the way, you're having a second-year medical student who is now going to be doing this intubation because there's no one else to do it. You need to know that. I am really disappointed in our Department of Health. You can argue about what the feds are doing. Minnesota's in charge of ourselves. We're still facing unclear standards at all kinds of places and insufficient equipment at these long-term care places, which I think is horrible. We have a governor who has issued 50-some orders affecting the entire state, and we can't go find the boxes of stuff to get to every one of these places, and people are dying in these places. And that would mean, Madam Chair, that the deaths that happen arising out of COVID, unless somebody is intentional, reckless, or grossly negligent, would be without recourse. So I'm very worried about this, Madam Chair, and I'm speaking only once today, but I've told you this to help you in your process. I hope something gets sorted out, but this is not it. Thank you.
Okay, thank you, Senator Abler. Senator Jensen, Wickland, Matthews. Senator Jensen.
Thank you, Madam Chair. I think the conversation is excellent. And again, I want to reference back to Senator Klein's comments. It seems to me like he and his colleagues have some of the toughest work. An earlier testifier said that the standard of care is constantly shifting. And it is. It's not just the standard of care, it's the expectation of what people have. And at Hennepin County, they may well be using ventilators, and 2 weeks later, they might have made a decision that would be different, saying we're going to do something different. The whole thing with hydroxychloroquine, the plasma, the convalescent plasma, the remdesivir. It just strikes me that the standard of care in this bill, what we're saying is because this is such uncharted territory, and one of the attorneys said that this is unprecedented. Well, it certainly is. I mean, we've never done this before. And he said it's very serious. Well, yeah, it's very serious. I mean, we've been in a lockdown for 2 months. That's pretty damn serious too. So I feel like in this bill, what you're doing is you've written in a new standard of care because there is no standard of care to reference. And the standard of care you're referencing is reckless intentionality and the verbiage that you've mentioned a couple of times. That doesn't strike me as being unreasonable. If there's a way that we can incorporate some of what Senator Abler is mentioning, where we do bring in clear notification so that there is that informed consent. And if there's some other things that we can do to help Senator Klein feel like we're not going beyond the pale in terms of what we should be doing. But right now, there's nursing homes that are worried, not that they have necessarily COVID-19 propagating throughout their facility. They're worried that they're making the wrong call by not letting person-to-person visitation take place in people's last week of life. And they're wondering if they're going to get sued for that. I mean, you can get sued for either side of what you do. So I really think this is an important effort, and I won't talk again on it. I just feel like if there's a way we could come to a happy medium, I think it'd be a good thing. Because when I look at how fast the recommended therapies are changing and moving, we're going to have the same issue with vaccines. If we get a vaccine, how are we going to deal with that? So again, Madam Chair, thank you for your courage to bring this forward. This is not an easy bill to bring forward, and I sure appreciate you doing it. Thank you.
Thank you. After Senator Jensen, Senator Wickland.
Thank you, Madam Chair. Yeah, I had a question for either Mr. Messerly or Mr. Carlson. I just wondered, after hearing the testimony of Mr. Lowe and Mr. Peltier, I'm wondering, is your statement about courts, they're required to take into consideration the circumstances, all the circumstances, does that take into account cases where things change rapidly in terms of standards of care? I mean, that's what I'm hearing a lot of from them, is that the standards of care, the recommendations are changing quickly over time. I guess what would the response be to that?
Senator Wickland, would you prefer Mr. Messerly? I believe he practices in this space, or Mr. Carlson?
Sure, Mr. Messerly, I guess.
Mr. Messerly, thank you.
And that's a very good question. I mean, the standard of care changes all the time with technology or knowledge, but the law that is written down, that is read to juries and that judges and lawyers must follow, takes into account all of that. So given all of the uncertainties today, there may be different uncertainties tomorrow, and the law takes all of those into the account. That's why our law about negligence and taking account of the circumstances has been the law for generations, because it accommodates disasters, it accommodates lack of knowledge. We want to encourage healthcare, and if people do their best job under the circumstances, the law does not second guess that. And that's been the law for ages, and it's probably going to be for a long time, because it accommodates situations like this.
Senator Wickland?
Thank you, Madam Chair. Yeah, I guess I'll just say just my thoughts. I guess at this point, I'm pretty uncomfortable supporting this bill, certainly as it is. And I guess, I understand that you're still working on it, Senator Klein's still working on it. I'm very uncomfortable about the long-term care area, especially reading the materials that were provided by the organization that sent us a handout today. And so I wish that, obviously we don't have the time right now, but I wish we were able to hear what changes you were thinking of coming up with respect to some of these concerns. And yet I understand that we probably don't have that time, and it has to move on to judiciary to get their examination. But I can tell you, I think it is too broad, and I'm uncomfortable supporting it at this point.
Thank you. Senator Matthews.
Thank you, Madam Chair. Just quickly for the record, I'm a law school graduate, but not a practicing attorney on the first hand. But thank you for that. I do have a question that I'd like our testifiers, at least one on each side, to weigh in on. Maybe I don't know I don't have a preference between like Mr. Carlson or Mr. Mesterly. I suppose whichever of them feel most comfortable to jump in, and maybe Ms. Thurlow on the proponent side. I'm wondering if you agree, are there only two options? Are you either acting in either good faith or intentional or reckless misconduct or gross negligence, good faith or bad faith? Or is there some gray area in between acting in good faith, then something that's not either, and then something that's harmful or reckless? I'd like to hear from both sides if they agree with that. If you think that there is a gray area in between, what do you think this law is going to impact in that in between? Because this bill talks about you're going to be immune if you're acting in good faith. You will not be immune if you are reckless or negligent. What would happen in the middle section? And I'd like testifiers on both sides to weigh in on that.
Mr. Carlson unmuted, so we'll start with him.
Sure. Thank you, Senator. That's an excellent question. I want to make sure that we understand that if you're negligent under this bill and it results in a harmful injury to someone, you're protected. This bill would give you absolute immunity for that kind of conduct. So what is the gray area? One of the things we're trying to understand is what type of injuries that are negligently caused are we trying to protect with this bill? Because this protects all negligence, everything. And if you want, I can send you what intentional conduct is, what reckless conduct is, what willful conduct is. You would never get to that level of misconduct in a medical negligence setting. And not only that, this bill, if you did, that would maybe even be criminal conduct. And this bill immunizes your criminal conduct as well. It's not just civil. This bill immunizes your criminal conduct. This is an absolute immunity, and the good faith provision in there is superfluous because it is consumed by intentional, reckless, and gross negligence.
Okay, thank you. And Mr. Peltier, you're unmuted. Please answer the question. There's some middle ground, or is there middle ground between good faith and intentional, reckless, gross negligence?
Thank you, Senator Benson. I think that the good faith standard is the most important component of this. It's the most easy to understand for individuals and for people to figure out. I am absolutely open to alternative language for subdivision 3 exceptions. I think that the Good Samaritan law in the state of Minnesota, which I think this is analogous to in a lot of ways, uses a good faith standard. Uses so there are. I'm sure that there is some sort of better way to draft this language that maybe people will be able to work out over time. But I think that individuals acting in good faith is the most important component of what we want our healthcare providers doing in this situation. They know they're limited. They know they're going to be put into positions of making very difficult decisions. We go through a laundry list of the types of decisions that have the potential to end up in a lawsuit. But again, the most important component here is the good faith nature of the individuals who are acting. And we're trying to set it up in a way that people are encouraged to do the work that needs to be done here and don't have this additional burden of the fear of being sued for it.
And Madam Chair, the distinction the distinction that I'd really like the members to think about as it relates to Good Samaritan. If you read 604A, it will tell you that only applies to people who are not being compensated or who have no expectation of compensation. Those are complete volunteers, and that is a completely different concept than what we're talking about here for paid and insured professionals. And getting to a negligence claim in Minnesota, and I disagree with Mr. Peltier, we haven't talked about the legal protections that Minnesota has had in place since 1986 that require the lawyer to review a case with an expert before he can even file the case to show that they've deviated from the standard of care. And within 6 months of even serving a complaint, you have to file your expert affidavit with all of the material facts. When he says this all gets sorted out at the end of a case, that is not true in Minnesota. We have a nation-leading system for filtering out cases, and we only had 77 malpractice cases in Minnesota in 2019.
Thank you, Mr. Carlson. Mr. Peltier, you had your name up, and I mean, lawyers fighting is how we're going to get to the right answer on this, but this is not judiciary. Mr. Peltier.
And thank you. I'm good. I don't need to respond.
Okay, thank you.
Madam Chair.
Mr. Carlson, could you help me understand? Mr. Carlson, if you could unmute, please. I don't know if he hears me.
I'm here.
There you go. Great. So I did have a question because we do have to have a medical expert. So let's say one hospital has different treatment protocols for COVID cases than another hospital, and they have different outcomes, deaths per capita, deaths per COVID patient, ICU, length of stay, et cetera. Do medical experts look at that circumstance and say both are equally good, or would they make a judgment and say one is better than the other?
Yeah, I should probably have Chris weigh in on this, but I can tell you that they're judged by their individual facility, their individual care that they provide at the facility that they are practicing in, and not what would you do at the Mayo Clinic. And so the law does differentiate. And what I should do, Madam Chair, for the members is send the committee members the information I sent to you yesterday with the civil jig that tells you what the standard is, how they judge that within the circumstance at the time, so that everybody has an understanding of how these cases would be considered in the current circumstance of a COVID-19 pandemic.
Thank you. And Mr. Carlson, do you think when the pediatric nurse is asked to go work a vent case, she's going to be confident that an expert's going to side with her? Do you think she'll be confident that an expert's going to side with her?
Well, first of all, you have to anticipate that something bad happened from that care, which we're not making that leap to begin with, because we have great confidence in our care providers, and we're not looking to have cases here. I mean, these people are doing an outstanding job, and we're not looking to defend cases. What we're looking for is we don't want the legislature to take away our legal rights when something does go wrong. And
I understand that, and I don't want to. I have never carried a tort reform case. So for me, it's the peds nurse who gets training on events so that they can respond to a case when the hospital is being overwhelmed, which we don't know if it's going to happen, but we're building, and all the medical professionals are preparing for it. And so is she going to be comfortable saying my good faith effort is enough?
Again, what I can tell you is that she would be judged, her care that she rendered would be judged based on her skill level, what she did, what her training was when she stepped in to do that help. It wouldn't be judged against someone who does that every single day, and that's their job. The standard, as I sent to you, that they would apply would consider the conditions that care was provided. And in that instance, an emergency situation where you're filling in, those are not the kinds of things that are the basis for medical errors that result in litigation.
But Mr. Carlson, if nurses know this, then why are they worried about it?
I think that, one of the things that we don't give enough emphasis on, I'm okay, and I think we all should be okay with someone being thoughtful about their job. We don't want them to be terrified to do their job, but being thoughtful about it is not a bad thing. and how you go about doing your job and being considerate of, I don't want to cause harm. Those are good things. And I think that the practitioners I've talked to are all approaching it in that fashion. What can we do to provide care, quality care? And not a lot of them that I've talked to are worried about the first thing that they're worried about is liability. I think their insurance companies are worried about it, and I think administrators are worried about it, but I don't detect that from providers that I talk to or first responders that I talk to.
Mr. Carlson, no insurance company approached me about this. I asked for this language because of conversations with actual providers.
I understand that. With
providers who'd gone through training so that they could respond in circumstances they never foresaw. This for me isn't to protect an insurance company. This is so that in the next 3 to 4 years, when we have the luxury of hindsight, those people who did the very best that they could in circumstances where there was no personal protective equipment. It's not that it's in the middle of March. There were not warehouses full of protective equipment that hospitals were just keeping from their staff. There were literally boats being stopped in harbors in China, keeping protective equipment from getting to our shores. I talked to a hospital executive not in this state who chartered a plane to go to China to get personal protective equipment for his staff. This is how closely I've been talking to people who do this. And so I think some of the language might go too far, and we need to find a narrowing. And we're not pushing this beyond COVID, and we're not pushing this beyond people who are trying to do the next right thing. I have really no idea what insurance companies think of this because none of them have talked to me. And please, this isn't a request. I don't want to hear from insurance companies. I need you to help me, Mr. Carlson. I need you and Mr. Meserly to find the words that we can put in the immunity and the exception so that we can tell our providers, you know what, Minnesota's got your back, but not for everything, just for the things that are really essential. And that's what I'm looking for. I'm going to go to, I'm sorry, Senator Marty, I went on a diatribe. I won't make closing arguments. Senator Marty and then Senator Hayden. Senator Marty, thank you for
Madam
indulging
Chair. Sorry, I was having trouble with unmute. No, I enjoy this discussion. It's a very difficult discussion. I chaired Judiciary Committee a number of years ago, have these discussions all the time. And I frankly think that we can go on with this as long as we want. Right. When the time comes, I want to move to refer this to Judiciary Committee without recommendation. I don't feel comfortable voting for it in the current shape. And I think it is a good bill that we have to take a look at this whole issue. So I think that's where these decisions are going to be made, not by us listening to both sides right now. And when you do this week after week in Judiciary, you get the lay of the land much better. So it's just a point that when the time comes, I'm going to move without recommendation.
Thank you, Senator Marty. And next, Senator Hayden.
Well, good. Well, thank you, Madam Chair. And I think it's a lively discussion. It tells me why I'm not on the Judiciary Committee and will never be on the Judiciary Committee or want to be. That's a joke. I'm sorry about that. But I do think it's a lively discussion. I think for the purposes of our committee, though, I did really enjoy hearing the provider perspective, Dr. Jensen and Dr. Klein and yourself, Madam Chair, who's had a lot of experience working on these issues, and a number of us. In addition to that, I think what was absent was, and I appreciate Mr. Carlson, Mr. Meserly, Mr. Peltier, and others. I don't want to dismiss the lawyers, but I also think that and Ms. Thurlow, I don't want to miss you either, but I think that the patient or the advocates for the patient is missing in this discussion in the healthcare setting to just get their perspective and take on this issue. And then, we did hear from the provider perspective. I would, Senator Marty, am going to vote to send it to the Judiciary for you guys to work on and figure out. If you can't get it done in 3 days, maybe we can get it done in June because we all know that we have to come back then. But I really do think that in this committee, and I do appreciate you bringing forward just understanding the providers that have to do the work and all of their various trainings and licensures and what they might have to do and feel comfortable. And then secondly, the advocates or people that represent patients and that side of it to just get a sense. We did get some emails on that. So with that, Madam Chair, I support Senator Marty's motion when he makes it and allow you guys to work and then allow the lawyers to kind of get together and figure out what's the right language.
Madam Chair?
Senator Jensen.
Thank you. Would Senator Klein yield to a question?
Senator Klein's next on the list. So are you
I'm sorry.
to Senator Hayden's point, or can I come back to you after? Okay. To Senator Hayden's point, a question for Senator Klein.
Yeah. Senator Klein, in lieu of Senator Hayden's comments, could you also comment on, do you think that this bill can get where you need it to get in order for you to support it? Or do you think that we're just not going to be able to get there? If you don't mind, because I hear Senator Hayden being respectful of you and I and appreciating our input. And I just like to hear your comments on that, if you don't mind. Thank you.
Well, yeah, thank you for the opportunity. I thought that Senator Hayden raised a pretty trenchant point about the fact that we don't have patient representation here at the committee, and I'm not sure how we would achieve that, in the area of COVID and so forth. But it is a good thought, and we do have to try to look through the lens of a patient and their perspective. And so, yeah, I think the comments that everyone, Senator Kiffmeyer, Senator Franzen, have brought forward are certainly meritorious. We want to protect patient rights and health. And I will continue to work with Senator Benson, who's just been scrupulous on this issue. And I think we should, it's our obligation actually, and our urgent charge to get it to a place where it's acceptable to both parties and all legislators. It's worth noting, as long as I have the floor, sorry to go long, Senator Jensen, but just for the edification of the committee, 20 states have already passed legislation like this. The first to do it was New York. And obviously they saw quickly that as we compete state to state and the need for providers and so forth, they were going to need to bring in nurses and physicians rapidly from other states. So, we will be possibly in the same spot if there are national hotspots, and providers may have the opportunity to go to a state that has some sort of blanket immunity and other states that don't. And I know which choice they'll make. So just another consideration for the committee.
Okay, thank you. So continuing the list. So Klein, back to Jensen, Abler, and then we are going to be open to motions. So Senator Abler is next.
No, I was next. Thanks. And Madam Chair, this is a topic that's worthy of discussion, but if you have noticed, it's very complex. 3/4 of the comments I offered in the beginning of my comments are doing any of these kinds of discussions where there's a quest to lower liability for patients. And so you're walking into a very historic pathway that many have trodden. And I think it's good that it's you with your good intentions. And so there are some ideas like rebuttable presumptions and so on that maybe could help. And so I would love to vote to send it to judiciary because that's where it should go. And not that that's any kind of a wish, a pox on your family, Madam Chair, but it's a good place to go for this kind of topic. And so I'll leave it at that. So I'd be happy to vote in favor of that kind of a motion.
Okay, members, then we go to Jensen, or did we finish Jensen? All right, Senator Hayden, your hand is still up. If you have a question.
No, sorry, Madam Chair.
Thank you.
Madam Chair?
Senator Jensen.
Since you said my name, I do want to just follow up on one thing that Senator Klein said.
I'm gonna stop doing that then. Go ahead, Senator Jensen.
I feel like I don't want to
Franzen's name, she didn't unmute.
Madam Chair, I just felt I really felt compelled. Thank you.
Go ahead.
And I know Senator Klein was at the edge of his seat waiting to hear what I was going to say. So what I was going to say is when I called out to New York, and there were 4 or 5 of us that were thinking about going out there and helping out when they're hitting their surge, one of the first questions they asked is, what are we going to do about liability risk? and they said, what does your contract in Minnesota do? They said, we can help you out with some emergency stuff, but we don't know that we can take you from your normal course as a primary care doc, put you in a ward where you'd be adjusting ventilators. So there was really, it is a big deal. And Senator Klein said that himself. 20 states have done it. If we have a surge where we need it, we want to be prepared and ready. I'm done, Madam.
Thank you. You can call me Michelle, but not in committee. Senator Draheim, last point.
Thank you, Chair. Just a quick clarification. After judiciary, is it coming back to our committee or is it going right to the floor?
It will not come back to our committee. Senator Draheim, we do not have, we're under 80 hours.
No problem. Thank you.
Left. Thank you. Senator Klein, would you like to make closing comments?
No closing comments, Madam Chair. I'd be glad to move the bill for you if you desire.
Go ahead, Senator Klein. I did my closing argument.
Thank you, committee, for hearing the bill and for the trenchant comments. I move that we pass 4603 to Judiciary Committee with no recommendation.
All right, members, I'm going to need you to unmute, turn on your video.
This is where they caught me when I said.
The motion will be to Judiciary. Senator Marty did request a motion to move without recommendation. Senator Klein, what would you like your motion to be?
Yeah, I move that we pass 4603 to Judiciary Committee with no recommendation.
And so, Senator Klein, the motion would be 4603 as amended, be moved without recommendation to the Committee on Judiciary. And so I need people to unmute. All right. All those in favor of Senator Klein's motion, say aye.
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 Anyone opposed to that motion? Okay, thank you, members. Senate File 4603 is on its way to Judiciary. Thank you for your help. And thank you to everyone who stayed on for 4603. We obviously have completed our questioning for you and you have other things you need to do. So members remaining on our agenda for the last meeting I anticipate us having, given the lateness of the hour, I'd like to take Senate File 4500 from the table. And where we left off, members, it had been amended by the A2. Senator Abler's A11 was on the table. So Senator Abler, I understand that you have an amendment that has had a significant amount of work done to it. And if you could tell us what that amendment is and how it's changed from the A11.
Thank you, Madam Chair. And I'd like to move the A16. And this is basically, it's been through the Slim Fast program. There's a lot of the same there, just there's a little less to love. I do have an oral amendment I need to make. Just on line 1.15, if I could delete the word employees, comma. And I'll just incorporate that and explain why that's important. Speaking with some of the business folks and other people, surprisingly, I never got a call from the Department of Health people at all, which I thought I might have attracted one of those. But anyway, talking to people that a good number of people, it made sense to me to make this simply a Bill of Rights and then an award of some grants to small employers. And the whole idea about contact tracing is a very worthy discussion. Minnesota already does this. And I don't personally know why we have to do anything to expand upon that because they're already doing it. They do it for measles, they do it for syphilis and tuberculosis and all kinds of things already. And I think what's missing in this And part of the hint is that some people aren't getting tests, is they're frankly frightened to be part of the system. And so I think the biggest need, and I think the statement coming from this committee, a productive message would be, let's make sure that people feel like they're protected in their privacy, and that they can be confident that they can't be forced to participate in some of these activities, and they can just go get their tests. For sure, we want them to be tested to find out if they need a test, they should get one. And so that's what this bill is. It's the highlights of the amendment it's page 2 of the amendment from last time, with the deletion of anything to do with an employer. In the same way that it's an interesting experience to dig into immunity and that law, employment law is far beyond our committee, Madam Chair. And so there is virtually no reference to employers in here anymore. It's simply a statement of the Bill of Rights people have as they deal with the Department of Health and their testing and contact tracing. And so then at the end, there's $5 million a year in grants to small employers. And people had asked about those, and the department would set up a program how they would award those grants. And so there was concern, are there good tests or not, all that. And so the department would make sure that their grantees would be using good testing procedures and all of that. So, Madam Chair, that's the amendment.
Okay, thank you. And Senator Abler, did you want to fill in any fiscal amounts?
Oh, I'm sorry. I just 5 million and 5 million. So, Madam Chair, I'll put a 5 million in the first blank on line 2.23 and 5 million in the second blank on line 2.21. 2.23. So both of them.
Okay.
And I'll incorporate that. Thank you for that question.
Thank you, members. Questions to Senator Abler's amendment? Senator Klein. Oh, there, your hand is up. Senator Klein.
Well, thank you, Madam Chair. Are we on the A16, Madam Chair?
We are on the A16, yes.
Because I'm reading the A16, and Senator Abler has just reassured me that there's nothing about employers in it, but line 2.12 says grants to employers, and it goes on like that. Actually, this would be more attractive to me as an amendment if it didn't have that as it was represented, but it does.
Oh, Madam Chair, let me improve what I don't think I said it clearly. There are no duties of employers in here. In the first draft, there were considerable duties that employers were given about some of these same standards. We are silent on the duties of an employer. And I think the reason that I was fond of the grants to them, which would be nothing to do with us running how they're going to do any testing, it'd be all under the Department of Health, would be that it shows that we are, as a committee, interested in testing and that we support that. And I think that of all the people that are going to need help with some of these tests, it's going to be these small employers who are not gifted, or they're not practiced in this. So that's why that's there. And so thank you, Senator Klein.
So Senator Klein, was that clarifying for you that language refers to the grants to help employers when they want to do testing?
Hi, I'm still on HHS.
No, hi, Julie. Yeah, it is clarifying it. I guess I still disagree with the mechanism and the intent. I'm not sure how I feel about an employer, say at a pork producing or processing plant or at some other environment, having some authority and financial control over testing when their employees do not have a patient-provider relationship with them. That's not a relationship of responsible trust. So I would raise that red flag for myself.
And
Madam
thank you.
Chair.
And Senator Abler, just one moment to
Sure.
Senator Klein. We did have, when we had outbreaks, we did have food plants who contacted a medical facility directly and had tests brought out so that they could have an entire day of testing, but it was contracted with Mayo or Stanford Health. It wasn't the employers buying the test. On the other hand, Major League Baseball did contract with the lab and have serological tests sent out to their employees. And so I think that's sort of the spirit that Senator Abler is working in here for those small businesses that might not have the resources for broad testing, but want to be able to offer it. So Senator Abler, to your
Thanks.
amendment.
And Madam Chair, if you Yeah, and those are valid points. I don't know that they're going to have their own test kits sitting there, but if you read the language on 2.12, we're talking about opening Main Street, which has been on my mind. I'm looking forward to opening bars and hair salons and making sure those employees are safe. And it says on 2.12, the commissioner shall award grants to employers to assist the employer in establishing COVID-19 testing of employees. And it goes on that they'll develop applications and so on. And it talks about priority should be given to employers that involve high-risk sites. But that's particularly vague, and it doesn't say that they'll even have the test there. But maybe they'll contract with a clinic. There'll be some site that's approved, that there'll be a grant they can send people to go, so they'll be without fear. So anyway, it's purposely vague, and the department actually likes that kind of vagueness. So then they would set up some program that made sense to how they could facilitate. My favorite shoe store on Main Street in Anoka, which has a couple employees.
I've been
so
there.
Those kind of folks. So
Senator Abler,
I'm done.
thank you. Thank you. And I think we have some members, a member of the public.
Thank you, Madam Chair.
I'm looking for Bentley Graves, and then I see Senator Marty's hand is raised, and I just saw Senator Hayden unmute. But I know that Mr. Graves had weighed in on this last time. I'd like to hear from him on the A16. If he's unmuted.
Thank you, Madam Chair.
Thank you.
Yeah, I appreciate the opportunity to speak. Bentley Graves from the Minnesota Chamber. Appreciate the opportunity to have some continued dialogue around this amendment of this language since the last hearing yesterday, the day before. I'm not sure, but yeah, I'm mostly here just to kind of, I guess, answer questions if there are any. But appreciate the movement of the language, and as I noted before, as Senator Abler noted, there are a whole host of requirements and guidelines that employers must operate under when it comes to testing or care for their employees in time of pandemic, ranging from the EEOC to the CDC, and that's much of that is also implicated in current executive orders binding on Minnesota employers today here in Minnesota. But anyway, I appreciate the opportunity to appreciate the work that's gone into it, and happy to answer the questions. Thank you, Madam Chair.
Okay, thank you, Mr. Graves. Senator Marty?
Yeah, thank you, Madam Chair. As we discussed last week, and since then, that the direction has changed from being one where we're looking at establishing a contact tracing program to go with testing to one where we're putting in a Bill of Rights for people who get contact tracing possibly. And I think we should be doing the other approach. I'm opposed to this amendment. I guess I have two specific things too, one of which is this idea of giving grants to employers, the shoe store with 2 employees in Anoka. It may be a good thing to do, but we've just put $40 million into having 2 of our medical institutions set up a thing for testing around the state that's supposed to be available to everyone, saying, well, we'll go individual employers to do their own thing too. On top of that, this is another $5-10 million. We're pumping money out the door fast, which we may have to do, but this strikes me as being very redundant on their testing. And then the second one is for the Bill of Rights. I think it's very appropriate we do. I think we had the speaker from Department of Health last week telling us that there are already a lot of protections in the law, and whether it was, I don't think it was the representative of MDH, but I think somebody else was pointing out that to do testing in the state, we do not require for a lot of testing and so on, we may not require written consent. I think we may be going a little bit too heavy-handed in terms of more steps to take that aren't really protecting people more. So I guess I'm not opposed to the idea of a Bill of Rights. I think it's a good idea. I guess I'm not sure what's already in the law and that this is helpful. So those are my 2 big concerns, but I'm opposed to the amendment because of that.
Okay, and thank you. And Senator Marty, one of my concerns is Mr. Huff consistently referred to HIPAA. And when I was reviewing recommendations from MDH to hospitals on reporting testing, they actually told the hospitals that they didn't need informed consent to share the data. And the hospitals wrote back and said, I think we do need informed consent. And so I think there maybe isn't the clarity that Mr. Huff represented. There was a claim that they could do a certain kind of tracking and syndromic surveillance. And the department, in a contradictory place, said, well, that's not what we mean to do. There at one point was a paragraph on the website about the information they were collecting. And they said, well, they hadn't planned to at this time. They wanted to use this for follow-up for other emerging health concerns. And so that makes me a little nervous. And so and Senator Marty, to your point about University of Minnesota and Mayo, yes, we gave them a lot of money, but they're still charging for the test. So if you're a small employer, you might just need a little help that you couldn't otherwise get, or if you have cash flow problems. So they're still charging for the test. The price is much lower than it had been before. And so I completely respect that this is not the path that you wanted to take. And it's not where we started. And
Madam Chair, I'm not bitter about that. Madam Chair, I'm not bitter about that. I'm disagreeing, but I am saying my concern about the Bill of Rights provided here. I don't know that we do written consent for a lot of testing things. Consent, yes, informed consent, but I don't know if it's always written. And I picture if I'm driving up to a place to get a COVID test, a drive-through COVID test, I picture I'm kind of consenting to it by choosing to go there. And maybe they do require a written test. I'm not sure they do, but maybe they do, and maybe this is redundant. I'm not sure that that's one of the things I would add is a patient's Bill of Rights type of thing. So in other words, I'm saying I'm not opposed to a Bill of Rights. I'm not sure we're there yet. And I also do have a question. Yes, I understand your good point about the fact that they may still be charging for the test. But are we going to give the employers to do it? So what if somebody else is trying to get it as an individual and they're not sure they're covered for it the way we said it was going to be, where testing was going to be free? So I'm just not sure putting how much you want to put in the blanks. $5 million a year. Okay, well, that's pretty arbitrary. So I guess that's my concern about it. I don't think it's fully thought out there.
Okay, thank you. Thank you, Senator Marty. And I do have Senator Nelson next on the list. And then we're going to go to a vote on your amendment. And Senator Abler, you can make your closing comments. Senator Nelson, to the amendment as drafted. And we do have a hard stop here in about 6 minutes. So Senator Nelson.
Thank you, Madam Chair. I just have a couple comments, questions. We did fund significant testing, and I did want to state that the cost is relatively low. I think it's about $66 a test. So certainly we'd want to recheck on that. That was the numbers from probably a week or so ago. So it doesn't appear that the cost might be the big issue, but perhaps I'm wrong. We're all stressed in many ways here now, particularly financially stressed, and particularly our businesses that have been shuttered. So I understand that. But my question goes to the quality of the test. So we know that testing is going to help us safely move through opening more of Main Street, Minnesota. And the key thing is that the tests are high quality tests, and also that they have a rapid turnaround. And you've probably read the reports that some of the tests are not as accurate, and some have a long turnaround. And if a test is going to be helpful, number one, it's got to be accurate, and number two, the shorter the turnaround time in getting those results is very important. Although we know there's probably a dynamic there between how effective the test is and the time. So some have said the longer it takes, the the longer tests are more effective. But I just think there's a balance there, and I don't quite see this in this bill as far as making sure that the tests meet some sort of standard or quality, so that we have confidence in those results. That's my biggest question on this. And I definitely support certainly a patient's Bill of Rights here, or testing a Bill of Rights. But the real question too is, how does, we have all kinds of tests that many of us have on an annual basis, and our medical providers provide all kinds of tests. And it seems like this is like just for the COVID-19 test. And I would want to see, how does this line up with all of the other testing regulations that we have?
Senator Nelson, I'm not sure where that fits to this amendment. So the FDA is recalling a whole bunch of tests, but we need to focus on this amendment because I do have a hard stop so we can get to Rules Committee. So was there something specific in the amendment you wanted to comment to?
Well, my comment in the amendment is it gives grants for tests without any type of notice about what those type of tests are.
Okay, thank you, Senator Nelson. Senator Abler, to your amendment, the A16 as amended.
And just two things, Madam Chair. One is I thought I might take that written thing out, and I forgot to take that out. So I think I'd like to move to delete the word written, because I think that's an improvement. And I'm sorry that we didn't mature it in the beginning. And if you can tell me what line it's on.
Senator Abler?
1.18, Madam Chair.
Yep. Senator Abler on line 1.18, delete the word written.
And that's my motion, Madam Chair, and I'll incorporate that into my amendment. And then finally on the testing
Senator
part.
Senator Abler.
Yes. Can I do that?
1.28. At the end of the sentence, you'll want to delete the word written.
I will do that too, Madam Chair. So in both cases, I'll delete the word written.
Okay, Senator Abler, final comments to the amendment as amended, and then let's move the amendment.
And thank you, Madam Chair. I believe the motion will be to finance, and I have to admit, I have no idea.
Yep,
Madam
Senator
Chair.
Abler, we're on the amendment. We need to vote for the amendment.
Oh, no, I can incorporate it, can I?
Yeah, we haven't put it on the bill yet. Ms. Kavanaugh unmuted, which makes me nervous. So Ms. Kavanaugh.
Madam Chair and Senator Abler, also on 2.6, there's a written.
Sure.
2.6. Thank you, Ms. Kavanaugh. All right, Senator Abler. So on line 2.6, the word written is deleted. Senator Abler, on the A16 amendment as amended, and then we're going to put it on the bill, and then we're going to make a separate motion for the bill.
I got it. So anyway, just to all the parties with concerns about the testing part of this, and I think it's a strength to help these employers. I think the department will sort out the proper testing and methods, and I think finance can help plug a better number in there that makes sense. So that's my thought about that, and I'm done.
Senator Abler, we need to go to judiciary. So
actually, I thought they waived it.
Nope, they didn't.
It's fine with me.
So
let's move. I'll move the A16 as amended.
As amended. Unmute video. All those in favor say aye.
Aye.
The amendment.
No.
Thank you.
Aye.
No. All those opposed?
No.
No.
It's a hard audience, Madam Chair.
Senator Abler, the A16 is adopted. We are now on Senate File 4500 as amended. We have about 10 seconds for comment. Senator Jensen has his hand up. Senator Jensen. Senator Jensen.
Thank you, Madam Chair. I just think that a Bill of Rights would go a long ways towards rebuilding the trust. I think folks out there are confused. The testing quality hasn't been what we want it to be. The robust 10 to 20,000 tests a day that we wanted to get to, we haven't. People have wanted to have tests. They haven't been able to get them done. And now we're starting to see people's appetite to get tested fade. So I really think a Bill of Rights, protecting the patient's interest is an important idea. But I want to have nothing to do with encouraging MDH to do any more than what they choose to do on their own. I really think we have to remember that locally, every county has some sort of a public health service. Every hospital has some sort of an infectious disease committee. Every clinic has an awareness of what reportable diseases are and what their obligations are when those diseases come up. So it isn't as if we are helpless without the state. We have multiple layers of intervention to help do the right thing. And I think a Bill of Rights would go a long ways towards resecuring the trust of the people, which I think has been fractured. When we send out addresses of active COVID-19 to 500 law enforcement agencies, we do that with
So, Madam Chair, I just, Senator Jensen's going long, and we might want to retort that, and you don't have the time. So I just want us to be fair.
I appreciate that. And
thank you, Chair.
Senator Hayden, I have Senator Marty on the list. He is your lead. Okay. Senator Marty?
Yeah, Madam Chair, I just wanted to respond that, again, I'm not opposed to a Bill of Rights. I think it's a good idea. I think we got the cart before the horse here. We don't have the contact tracing program in place, and maybe the Department of Health is going to be able to do it because apparently they can without legislative authority. But we don't have the program in place, and we are proposing a plan. If they put it in place, we'll do this. And I guess I think we should be spending a little more time trying to figure out what the appropriate program is. And I'm not saying that, in other words, I think that it's appropriate for the legislature to be involved in the decision making about how that program works and whether there's a Bill of Rights, which I think should be a part of it. I just don't think that this bill is in the right shape. And again, thank you, Senator Aber, for taking out the written, but again, I'm not sure if that's the right Bill of Rights here, and I'm not sure what exists right now. So I guess I feel unequipped to, I'm glad Judiciary is calling for the bill. I think they may sort out some of those things as well.
So thank you, Senator Marty. I've never heard let's fix it in Judiciary as much as I have today. So members, with that, Senate, I'm going to ask you to unmute, turn on your video, Senate file. So the motion will be Senate file 4500 moving to Judiciary.
As amended.
Right. I just want to make sure everybody, I'm saying it twice so people have time to unmute and catch up. So members, I move that Senate file 4500 as amended be recommended to pass and sent to the Committee on Judiciary. All those in favor say aye.
Aye.
Aye. Anyone opposed?
No.
No. Okay. Thank you, members. Senate file 4500 is going to Judiciary. And
Madam
with that,
Chair?
Senator Abler.
Just one last positive thought. I just wanted to announce that my Blue Cross is actually using staff to help with tracing contacts to their call center. In the past, I've been somewhat critical of some of Blue Cross's activities. I wanted to give them a shout out for doing a very nice thing. Thank you, Madam Chair.
Yeah, thank you. And there are a lot of partners. Senator Matthews raised public health partners to my attention, as did Senator Kiffmeyer. There are a lot of people. The hospitals have asked for a role in this as well. So there are a lot of Minnesotans rowing the boat, I think is what they say. Members, this is in all likelihood our last meeting. And because it's an election year, we don't know what happens and how things look when we come back. So I can have my vision. I know Senator Klein has mentioned a couple things a couple times, and I hope that you know how much I appreciate, in particular, your attention and your participation, and how hard sometimes you have to work to get a bill through this committee. Our work isn't always great. Sometimes it's sufficient, but it is always done with your enthusiasm, with your care and concern, your legitimate care and concern for the individuals we regulate, the entities that we are responsible for. When I think about it was so easy for me to decide to fund the public health lab in my first budget. And now I look at what that means. And then we get the privilege of being at the heart of decision-making on a global pandemic. We think about it differently than other people do. And so I hope you take a moment in these last several hours of this session, and there's a really good chance we'll come back for a special, but special sessions aren't as special as the end of session. So think about what we have done and what we do here every day, and don't let it just fly past you. I want to thank, oh, I just got a note from Bailey. This is our last hearing, so I don't get any choices about more hearings. I want to thank our staff, Katie, Dennis, Liam, Patrick, and Bailey, Larissa, and Ryan. I don't know how on earth we get through all the stuff that we get through and the number of changes that are accomplished. And we figured out how to do it on Zoom and tried to be as transparent as we could. We failed sometimes, but I think the public overall is better for the work of this committee. And I am grateful to each of you. Our work's clearly not done, so dig in. We have one really big issue outlying that I think we need to try to do in a timely manner. And with that, members, it is my honor and privilege for the last time this session to say the Health and Human Services Finance and Policy Committee is adjourned.
Thank you. Have a good day.
Thank you, Madam Chair.
Thank you, everybody.